Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce mediation and valuation services based in St. Louis, Missouri. Today, we're going to discuss the marital balance sheet, trusts, and divorce with Bob Boyd and Tish McDonald from Atlanta, Georgia. Bob is a co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery, and a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Tish McDonald is a partner in the trial and global practice group at King Spalding. She focuses on complex commercial litigation with an emphasis in trust and estate litigation. She also gets involved with litigation for nonprofits, real estate, and government entities. Have you guys seen other situations where maybe a trust played into it and it was a surprise in some capacity?
So I would suggest to you that a situation like you had is not that uncommon. And it's not a question of the moneyed spouse being deceitful, hiding the ball, whatever words you want to use. Very often these high net worth people share as little information with their children as they can. And it could have been a matter as simple as, hey, y'all go live in the family house, it'll be fine. And they've never really had to worry about anything. And so they're thinking, okay, fine, I got the keys. Let's go to the house. And it's all furnished and it's nice and we'll just live there. And eventually they start feeling like it's their own and they don't have to ask any questions because everything's taken care of. It's just not that uncommon, I've found, for the, if you will, the beneficiaries to not really understand what's going on because nobody's telling them.
Mm-hmm. And things get paid for, and so it's sort of a don't ask, don't tell.
That's right.
We're living great. Everything's fabulous. And
got a credit card, never write a check for it. Somebody's paying it, but life's good until it's not.
Right.
Well, and Melissa, one thing you asked about what sort of situations that we are seeing is sometimes you have a situation where a spouse, there's joint planning, the husband and wife go see an estate planner, they set up a trust, let's say for the kids, and I'll say the non-moneyed spouse is named the trustee. And then later in a divorce, that non-moneyed spouse goes, well, I didn't know I signed that. I didn't know you didn't explain it to me, moneyed spouse. Well, so that's not a really strong legal position for them because after all, they were there. Usually probably an estate planner was there and would be a witness to say, well, she understood or he understood. So now what we're seeing is a new theory rising up, at least in some of the states, of a breach of confidential relationship, which is a tort claim. Georgia's is probably way too broad right now. But Bob and I are seeing more of that. It's almost a catch-all tort claim, but it ought to be taken seriously because it carries with it punitive damages. Bob, do you want have any thoughts about that?
Take off on the case we had to try, Tish.
Yeah.
Those things do not get tried that often, right? I mean, these trust cases, just
right,
where they interface with divorce, because there's just too much risk. It gets way too expensive. But, our Supreme Court said some basic things like a husband and wife have a confidential relationship, right? And that's all they give you. I don't know what that means, but that's what they say. But that's a big deal now in these relationships.
It is. And I look, Bob, I took a look at some other states recently, and I have to say that my own personal view is I liked North Carolina's rule on confidential relationships between spouses. It simply says, I'll look at this, it says that spouses have fiduciary duties to each other with respect to distinct agreements or transactions between them. That makes sense. For example, a postnuptial agreement. Or if they enter into a business together, they've got to treat each other really, really honestly. But I still believe that a spouse who earns funds should have some freedom to do what they want to generally with their money. For example, if they want to make a gift to charity, they should be able to do it, not have to go run and tell the other spouse. And generally, it's a matter of size.
What did the Supreme Court opinion in our case say about that? I seem to recall something.
It said that that I'm not going to say what the Georgia Supreme Court said. We're not going to define now what the duty of disclosure ought to be with respect to financial transactions that one spouse takes apart from the other. But this one did not involve a $25 gift to the United Way. It's really just referring to the trial court. And in our case, the case Bob and I tried, the trial court found there was clearly no nefarious or fraudulent intent, so there was no breach of the confidential relationship. So that's what happened in our particular case. We prevailed on that point.
And Melissa, I want to go back a little bit to something you were talking about the formation of the documents and everybody participating. That's where, and I would suggest, while the documents are important, I think one of the also critical things that people have to understand, that if you ever have to prove something up in court, a judge or a jury is going to want to look at a timeline. And your timeline for establishing this trust, how it came about, who was involved, when were they involved, in this timeline, that really, to me, is the critical analysis in whether it stands or it falls.